In Arizona, real estate, understanding how agency relationships are created is one of the most important concepts for both compliance and professionalism. Every real estate transaction begins with some form of relationship between the licensee and the public, but that relationship must be clearly defined and lawfully established to protect all parties involved. The formation of agency, whether implied or expressed, determines to whom the licensee owes fiduciary duties, how those duties are carried out, and how liability is assigned if something goes wrong. Agency creation is governed primarily by ARS Section 32-2 153A3 and Commissioner's Rule R4-2 8-1101, both of which outline the ethical and legal responsibilities that arise once a licensee begins representing a client. Agency is the legal relationship that is formed when one person, the agent, is authorized to act on behalf of another person, the principal. In dealings with third parties, in real estate, the principal is typically the buyer, seller, landlord, or tenant, while the agent is the licensed broker or salesperson acting under a designated broker. When agency is properly created, it imposes fiduciary obligations upon the agent, duties of loyalty, obedience, confidentiality, disclosure, accounting, and reasonable skill and care that are enforceable by law. This relationship defines how information is shared, how offers are presented, and how the agent must prioritize their client's best interests throughout the transaction. There are two primary ways agency can be created in Arizona: expressed agency and implied agency. Expressed agency is the preferred and lawful method, while implied agency arises unintentionally and often results in legal disputes. Expressed agency occurs when both the client and the licensee clearly agree, verbally or in writing, to enter into a relationship of representation. In real estate, this is typically documented through written contracts, such as the listing agreement for sellers or the buyer-broker employment agreement for buyers. These contracts outline the scope of representation, compensation terms, duration of agency, and any other conditions that define the relationship. Expressed agency is reinforced by the Arizona Statute of Frauds, ARS Section 441017, which requires certain agreements, including those authorizing an agent to sell or purchase real estate on behalf of another, to be in writing in order to be enforceable. The writing serves as evidence of consent and ensures that both parties clearly understand the agent's authority and responsibilities. For example, a seller who signs a listing agreement with a broker has expressly authorized that broker to market the property, negotiate offers, and handle all matters related to the sale under the terms agreed upon. Likewise, a buyer who signs a buyer-broker agreement has expressly granted authority to the agent to search for properties, submit offers, and advise throughout the process. This written expression eliminates ambiguity and helps avoid misunderstandings that can lead to legal or ethical disputes. In contrast, implied agency is not created through a written or verbal contract, but instead arises from the conduct or actions of the parties. It occurs when the behavior of a licensee leads a reasonable person to believe that the agent is acting on their behalf, even if no formal agreement exists. For instance, if an agent consistently provides advice, negotiates on behalf of a buyer, or speaks as though they represent the buyer's interests without obtaining a written agreement, the law may infer that an agency relationship has been created. This is known as agency by implication. While implied agency may seem harmless, it carries significant legal risks. Once an implied agency relationship exists, the agent becomes legally bound by fiduciary duties to the client, even though there is no written agreement defining those duties. This can create conflicts, especially if the agent is also working with another party in the same transaction. Imagine an agent hosting an open house for a seller. A buyer walks in and begins asking detailed questions about how much they should offer and whether the seller is flexible on price. If the agent provides guidance that suggests they are acting in the buyer's best interest, an implied agency relationship may be formed with the buyer, even though the agent is legally obligated to the seller. This could result in a dual agency situation without disclosure or consent, violating R4-28-1101D and potentially subjecting the agent to disciplinary action by the Arizona Department of Real Estate, ADRE. To prevent implied agency, Arizona law emphasizes written disclosure and documentation. At the first substantive contact with any party, a licensee must disclose in writing whom they represent using the Real Estate Agency Disclosure and Election (READ) form. This disclosure clarifies whether the agent represents the buyer, the seller, both parties, limited representation, or neither. Making this disclosure early ensures that all parties understand the agent's role and prevents the unintentional creation of fiduciary obligations. Arizona case law reinforces the importance of clear agency creation. In Barnes v. Lopez, 1985, the Arizona Court of Appeals ruled that a fiduciary relationship requires more than mere interaction. It requires a deliberate, mutual understanding of trust and reliance. The court stressed that licensees must avoid situations where their conduct could reasonably cause a party to believe they are represented when no formal agreement exists. This case underscores why written, expressed agreements are the only safe and lawful means of creating agency. Expressed agency is further supported by Commissioner's Rule R4-28-1101F, which requires that employment agreements, including listings and buyer-broker contracts, be in writing and signed by all parties. This protects both the client and the licensee by defining duties, expectations, and compensation terms. Written agreements also serve as essential records for broker supervision under ARS Section 32-215-1.01, ensuring compliance and accountability throughout the transaction. Ultimately, the distinction between implied and expressed agency lies in control and clarity. Expressed agency ensures that all parties are aware of the relationship and its terms, while implied agency often leads to confusion and potential violations. A prudent licensee will always seek to formalize representation in writing before providing advice or performing acts that could be interpreted as advocacy review summary. Agency in Arizona is created either expressly or by implication, but only expressed agency, documented through written agreements, meets the state's legal requirements and protects both client and licensee expressed agency, arises from a clear, mutual agreement defining representation, compensation, and duties. Civil liability, Arizona Revised Statute, ARS, Section 12-2506D addresses liability and states that a party can be held responsible for the fault of another if the other person was acting as an agent or servant. That is where you may find yourself in a position of implied agency. Implied agency, on the other hand, develops through conduct that suggests representation without formal consent and often results in unintentional fiduciary obligations or dual agency violations. To prevent implied agency, agents must provide written disclosure at the first substantive contact using the READ form. Arizona courts and the ADRE consistently emphasize that transparency and documentation are the foundation of lawful agency creation. Discussion: why is expressed agency preferred over implied agency? Answer: expressed agency is preferred because it creates clarity, accountability, and legal enforceability through written agreements, protecting both the client and the licensee from misunderstandings. How can an implied agency relationship form unintentionally? Answer: it can form when an agent's actions or advice lead a consumer to reasonably believe they are being represented, even without a written contract. What document helps prevent the accidental formation of implied agency in Arizona? Answer: the Real Estate Agency Disclosure and Election (READ) form. which must be presented at the first substantive contact, clarifies representation roles. Closing remarks. The creation of agency defines the very foundation of real estate practice in Arizona. It determines who is represented, what duties are owed, and how the law views the relationship between licensee and client. By ensuring that every agency relationship is expressed in writing, disclosed clearly, and understood by all parties, agents uphold the trust and transparency essential to the profession. The difference between success and liability often lies in this early step, establishing agency properly, lawfully, and ethically.